Phil mentioned that you, Aaron, may have some final thoughts if you want to share them with the audience. And then, Phil, if you've got anything more you'd like to add, feel free to do so just before we wrap things up.
Sure, definitely. Thanks. I'll lead off, which is, in summary on the Duncan parking decision, we've only touched on a few of the things that were going on there, but there was a lot. And so one of the takeaways here is that when you're managing parallel proceedings in front of the district court and at the PTAB, which is something that Phil and I have both done a fair amount of, there are dueling evidentiary concerns, there are dueling standards, there's different standards of review, and there are different fact adducement requirements and abilities to adduce those facts through discovery in the different forums. And so managing those two side by side is something that's very tricky. And especially so here where the fact determinations were not being made by the district court where you tend to see them, but it was being made by the PTAB using extrinsic evidence that's not internal to the patent, the specification, and the file history. So that, it makes this case somewhat unique. And then in terms of the doctrine of equivalence aspect of it, I think Phil mentioned this is potentially quite significant in the mechanical arts. And I would re-emphasize that because if you read the decision itself, there's Federal Circuit case law to say that this type of doctrine of equivalence determination made in the mechanical arts when you're talking about structure is something that goes to an underlying issue of fact. And so it may have been inappropriate to decide on summary judgment. The Federal Circuit didn't buy that argument. The Federal Circuit just looked at the claim language here and said, you claimed this element. You can't now say that this element is something else because that would vitiate the element itself. It would read the element out of the claim. And I think it's a very important takeaway because I think a lot of people view claim vitiation as somewhat of a toothless doctrine because all claims have elements. So of course, if you're trying to expand the scope of a claim, it's going to change the element a little bit. But I think the takeaway here is that it's a fine line. You can expand that element, but you can't read that element out completely. And that's very important when you're dealing with structure, especially in things like the medical device space.
Thank you so much.
I'll turn it back to Phil.
Excellent. Phil, do you have anything to add just before we wrap things up?
I'm going to say two things. Ditto on what Aaron said. That way it's a lot shorter. And two, really, it shows you how two proceedings proceeding in parallel have advantages and disadvantages in terms of being able to do discovery at the same time that you're actually at the patent office where you may not get as much discovery. And so that's something always to consider, both that and finding other ways and other discovery mechanisms that you're going to be able to bring and put in front of the PTAB, which you may not be able to get at the PTAB alone. So with that, inventorship and inventive entity, vastly interesting. We only touched on it today. So thank you very much, everybody.